The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.
Coming up on the agenda.
The whodunits can very soon become Netflix entertainment, right? They really follow the ideas we have from mystery novels, mystery movies. And of course, these are not entertainment. This is about a lot of human suffering, not only for the wrongfully convicted, but their whole family.
Then,
human rights are not going to be promoted with legal mechanisms. They're only going to be promoted on the moral authority of the case that is being made across cultures, across political dispositions, across the north, south, east, west. Only when we focus on things that are so essential that no one can disagree with them can we build a global consensus that can actually make a real difference.
that's ahead on the agenda. It is almost unimaginable to be found guilty in a court of law for a crime you did not commit. Or imagine knowing you were innocent, but you pled guilty anyway because that seemed like the best option. Kent Roach is a professor at the University of Toronto's Faculty of Law and co-founder of the Canadian Registry of Wrongful Convictions. His new book catalogues the myriad ways that Canada's justice system makes such cases more common than you might think. It's called Wrongfully Convicted: Guilty Pleas, Imagined Crimes, and What Canada Must Do to Safeguard Justice. And Kent Roach joins us now here in the studio. It's good to see you again.
Good to see you,
Thank
Steve.
you for joining us. Okay, give us the numbers. I think I read in your book there's something like 187,000 cases before courts in this country every year. How many of them do they get wrong?
Well, we never know, but at the registry, we launched with 83 cases of wrongful convictions, and now we have 4 more that we're adding, so we're going to be up to 87. But it's only the tip of the iceberg, because these only measure remedied wrongful convictions. So if you assume that the legal system gets it right 99.5% of the time.
That's a big assumption.
That's a big assumption. But even then, there'd be 900 wrongful convictions each year, about 400 of those who would go to jail.
So this is truly the proverbial tip of the iceberg that we're finding out about.
It is, and it's an access to justice issue.
In the end, how many people who are wrongly convicted do you think end up inside a jail cell?
Well, I mean, given that, I would expect that it's probably less than 50%, but I think people that just get a conditional sentence or whatever, they often don't have the resources to remedy their wrongful conviction. I mean, if you and I had a conviction because it would affect our employment status and all that, we would spend the farm on it. But if you already have a couple of convictions and you get another one that's wrongful, I think most people just lump it.
Well, that does raise a question about what particular groups in society may have a tougher time getting access to justice and you know, the benefit of the doubt and all of that than others. Who would they be?
Well, you know, Indigenous people, there's 16 out of the 83. And you can look at that one of 2 ways. You could say that's overrepresentation from the 5 or 6% in the population, but it's not representing the fact that over a third of prisoners in Canada, the most serious wrongful convictions, are people that are in jail. Similarly, we have about 4 Black people, and we're adding 2 more Black parents to the list soon.
And we hasten to add, this is just the ones you know of that are on your registry.
Exactly.
This is not the sum total of everything.
Exactly.
Because we assume there's a lot more.
Exactly. And if you look south of the border, you know that with American exonerations, about 60% of them are Black people, even though only about 30% of the prison population is Black.
Look, this is my impression. You tell me if I'm wrong. My impression is there's not a lot of energy or effort right now in the official justice system to kind of do anything about that. And I'm not, laying blame here, because so much of what happens in the justice system is just designed to get through the day, right? Get cases in, get them out, get them dealt with, and so on. Why does so much of this so easily fall under the radar?
Couple of reasons. We haven't had a public inquiry into a wrongful conviction since 2008. We haven't had clear-cut DNA exonerations, you think of Guy Paul Morin, David Milgaard, those will eventually go away because in the minority of cases, and it's only about 20% of cases will involve biological evidence, the police will do their job and collect it, and if it's not the person, they're going to go free. And then finally, and while I was writing this book, I think the decline of investigative journalism. So much of the registry is built. I mean, we only look at publicly available documents. We don't want to contact people. We don't want to, harm people. We're a university. We have to abide by human subjects review. So much of our work was really done looking not only at court documents, which often don't tell the whole story, but media stories. And I've seen less and less investigative reporting. I mean, there's still people, Rachel Mendelson at the Toronto Star has done wonderful work. Of course, the late Tracy Tyler, Kirk Macon. But now most newspapers don't have the resources to devote someone to the long slog of uncovering a wrongful conviction.
You mentioned Kirk Macon, whom I know, but I mean, Kirk hasn't been at the Globe and Mail in, I don't know, 20 years?
Exactly.
So, yeah, I mean, it's...
and Kirk went on to serve on the board of Innocence Canada, so he felt strongly about this. So there are some people. We also spent a lot of time looking at regional and APTN, because APTN has done, I think, a much better job.
Aboriginal People's Television Network.
Aboriginal People's Television, covering the wrongful convictions of Clayton Boucher, Connie Oakes. These should be household names. Unfortunately, I don't think they are.
Right. Let's do an excerpt from your book. We all think dirty to some extent. The presumption of innocence and giving people the benefit of a reasonable doubt are fundamental legal principles, but they are also psychological and social fictions. As the cartoon Pogo recognized with respect to pollution in 1970, we have met the enemy and he is us. We all can believe that untrue and imagined crimes are real crimes. Okay, let's pick this apart a bit. An imagined crime, what's that?
An imagined crime is a crime that didn't happen. So I worked as director of research in the Gouge Commission, and we were looking at the Charles Smith cases.
Stephen Gouge is a judge who was in charge of looking into all of this.
And Charles Smith is a disgraced pathologist who said, these people died, these babies died deliberately as a result of foul play. When other pathologists looked at it, they said, no, these babies died because of epilepsy or because of undetermined causes. So an imagined crime is when suspicion that we often have then generates into a conviction or a guilty plea.
How much of that happens because people have preconceived prejudices about ethnicities of people and that kind of thing?
I think some of it does. I mean, with Charles Smith, the three men that were victims were all racialized. One was Indigenous, one was Dinesh Kumar, a new immigrant from India, and Onel Blackett. I also think, though, and this is a more delicate subject, it also comes sometimes in sexual assault cases, is that, thinking dirty about men is not an irrational thing. We know that men commit most sexual assaults, but it can also lead to this kind of shortcut where we just view things through the lens of guilt and don't give the weight we should to the evidence that suggests the person is not guilty.
Is there a distinction between imagined crime and a whodunit?
Absolutely. So the whodunit is Guy Paul Morin, David Milgaard. It's clear that a crime has been committed and we get the wrong person. And I kind of, this still happens. The Glenn Assoon case I talk about is a whodunit where we never found out who actually did it. But one of my worries and why I've really put the emphasis on guilty pleas and imagined crimes is the whodunits can very soon become Netflix entertainment, right? They really follow the ideas we have for mystery novels, mystery movies. And of course, these are not entertainment. This is about a lot of human suffering, not only for the wrongfully convicted, but their whole family.
What do you mean by the phrase thinking dirty about the criminal justice system?
Well, thinking dirty was coined about Charles Smith, because there was an attempt to try to deal with undetected child abuse, and that was a real reason. But I say we all think dirty, because one of the problems is we sometimes pathologize what are actually really common causes of wrongful conviction. So we can say, thinking dirty, that was Charles Smith. Once Charles Smith is gone, there's no more problems. Well, that's not true. Similarly, we talk about tunnel vision, and we're hard on the police about tunnel vision. But I explain tunnel vision to my students that if I'm reading a 3-question exam and the first question is not done very well, I'm thinking, okay, well, maybe this one's going to be a C that I can put on my curve. But at least I recognize that, right? I mean, it's just a human tendency, because we have too much stuff coming in our brains. We have to simplify it.
In a way, and again, you tell me if I'm out in left field on this one, but in a way, it is a bit of a public endorsement of how much confidence they have in the whole criminal justice system, that we assume the police wouldn't lay charges if there weren't something there. The courts wouldn't find somebody guilty if they weren't, because we have such faith in our judges. We believe in the jury system. I mean, that's all part of it, isn't it?
Absolutely. And of course, the jury system is something where, we have problems with the diversity of juries. We don't allow reporters to talk to jurors. I mean, there was a recent case in Ontario where one of the jurors went on a shock jock after and kind of spilled the beans about some of his homophobic attitudes.
And you're not supposed to do that.
You're not supposed to do that.
Yeah.
But that actually counts, in our view, as a wrongful conviction, because, we don't judge innocence because the legal system doesn't. That was a case where he was convicted and then it was undone as a result of new evidence about what that juror number 12, said to the shock jock.
I'm going to go a little off the path here, because you've taken me down an alley I want to just pursue for a second. In the States, if you're on a jury, you're allowed to talk. In fact, if you're on the OJ jury, you're going to get a 5-book deal or something like that. But in Canada, our tradition is you're on a jury, everything stays in the jury room. You don't explain, you don't defend, you don't do anything for members of the public. Which do you prefer?
I prefer the American. I mean, the American Supreme Court has allowed convictions to be overturned when there was evidence of racist stereotyping going on in the jury. Our Supreme Court in the Pan case reached the opposite result. And usually our Supreme Court is much more liberal than the American Supreme Court, much more kind of pro-accused. But this is an area where I think we're protecting the justice system. And that's one of the problems with wrongful convictions, is no one likes to admit mistakes. And so a lot of walls go up. And this is why we describe it as a long, hard climb to exoneration. So we use the mountain both to represent the tip of the iceberg, but the fact that it takes a lot longer to reverse a wrongful conviction than it takes for a wrongful conviction to occur. And in a guilty plea case, literally the wrongful conviction can take place 10 minutes in court time. Someone's looking at a murder sentence, looking at mandatory life imprisonment, which is still constitutional in Canada. They're offered a deal to manslaughter, infanticide. You got to have a lot of faith in the justice system to roll the dice. And most people will actually accept the plea to infanticide or manslaughter.
Okay, let me pick up on that then. How much, in your judgment, you've looked at this system for a very long time, how much of that happens where somebody is going to plea bargain down and accept a false conviction? They may not be guilty, but they're going to accept that because there's so much momentum in the system to clear cases, and you're afraid that if you don't do this, you could spend 25 years to life in jail.
Yeah, it happens, I think, every day in our justice system.
Every day.
And it happens both in small cases and in big cases. So an example of a small case, we talk about Clayton Boucher. Clayton Boucher was denied bail on a drug charge, and he was given an idea he could plead guilty, get time served. He served about 2-3 months in the Edmonton Remand Center, quite a scary place. He pled guilty, even though he knew it wasn't drugs, and the RCMP lab eventually said it wasn't drugs. Now, he made a rational decision. That's the little case. Big case is the murder cases. If you're a battered woman and you're charged with murder, and they offer you a manslaughter, and all of the abuse that you've suffered goes into maybe you don't even go to jail. Or like Maria Shepherd, one of Charles Smith's victims, she gets to stay in the provincial system. She doesn't go and have to sit with Karla Homolka in prison for women. She makes a rational decision that's best for her family. So not only is it irrational decisions, it's rational decisions. And I have to say, one of the things in the book is I talk about, I've been teaching criminal law for 35 years now. I have to say I'm a little more disillusioned than I was at the start.
I noticed that. You mentioned that in the book about how the longer you've been at this, the less optimistic you are about the future. Yeah. That's sad.
It is sad. It is sad. But I think a lot of us, as we get older and we see the same mistakes happening. But having said that, I'm not completely disillusioned. And there's a bill before Parliament that I hope gets enacted before the next election. I'm not so sure that could make things a bit better.
This was really the striking thing about the David Milgaard case, which many people may remember. We're going back 30 years now. The Indigenous fella who was alleged to have committed a murder went to jail, found guilty, went to jail. They offered him like a plea to get out, right, to manslaughter. They said, you plead guilty to manslaughter, you can get out for time served. And he wouldn't do it. No. He wouldn't take it. He insisted, I'm innocent, and I'm going to stay here until the system gets it right.
Yep.
How much of that happens?
Well, it happened for Donald Marshall. It happened for Bill Mullins Johnson. It happened for Tammy Marquardt. They're all Indigenous people. They all gambled, had faith in the system, and were all wrongfully convicted of murder. And so, as a person who is part of the system, who teaches this, I feel that that's a problem that we all need to take very seriously.
Here we go, back to the book here. The range of potential wrongful convictions is larger than we previously presumed. We can no longer assume that those who plead guilty are actually guilty. We also cannot assume that DNA evidence will solve the whodunit mysteries associated with our infamous wrongful convictions. We can't even assume that there was a crime. Given this reality, we'd better make sure we invest in the back end of the justice system to ensure that we correct our mistakes as quickly, humanely, and fully as possible. Okay, the back end of the justice system refers to what?
Well, it refers to post-conviction relief. It refers to appeals. It refers to now getting mercy from the Minister of Justice, the Federal Minister of Justice, when all your appeals are gone, and it refers to compensation.
How inclined or not are justice ministers to get involved when they are asked to deal with what could be perceived as an injustice in the system?
Well, I think it depends on the Minister of Justice, Irwin Cotler, and now his McGill colleague, David Lametti, I think have pretty good reputations for making decisions, sometimes quickly, to order new trials and new appeals. Other justice ministers, not so much.
Again, I'm going to infer here. You tell me if I'm wrong. You've just mentioned two capital L liberal justice ministers. Is it harder for a capital C conservative justice minister to do what you've suggested because they are seen, part of their brand is tough on crime?
I think so. And in the 2019 election, there were agreements by the NDP, the Liberal, and the Green Party to enact an independent commission to take the Minister of Justice's place. But I note the Conservative Party did not make that agreement. And so for me, one of the urgencies is if this Bill C-40 before Parliament, if it dies on the order paper before we all go trotting off to an election, and if there's a change in government, I'm not so sure it's going to be revived under a Conservative government. I hope so. I hope I'm proven wrong. But that's what I observe.
Yeah, clock's ticking, but this Parliament has lasted longer than anybody thought it would, and I think they've got a supply and confidence agreement for another couple of years, so theoretically, that's enough time to get it done.
Yeah, no, but again, this goes back to the disillusionment. I was the research director for Justice Harry Laforme and Juanita Westmoreland Traore in 2021 when they did public consultations, and we talked to the exonerated, we talked to the commissions that exist in England and 4 other countries. And one of the disillusioning things is one of the things that's happened in England is they've starved the commission of funds. And if the commission doesn't have the necessary funds, they can't do the necessary outreach, they can't do the necessary investigations, and they also can't support the wrongfully convicted as they go through this long process of trying to get justice.
You've got a website that's got all of this there. We should just tell everybody, wrongfulconvictions.ca. Your students are involved in this too, right?
Yes.
What do they do?
Well, the students donate their time, and we started this in 2018. Amanda Carling and I were teaching wrongful convictions together. She's a former student of mine, a Métis woman who worked 4 years for Innocence Canada. And we noticed that, the Americans have a registry, the English have a registry, where's the Canadian registry? So we thought it was a 1-year project. Turned out to be a 5-year project, and we're still kind of working on it. But the idea is you can go there, you can read about the 83, soon the 87 cases. We also have a timeline of injustice, because I think for Amanda, especially as a Métis person, it was important to include Louis Riel and other people in that. And so we hope that it's a source not only for law students and researchers, but high school students and the public at large. And it's free, so you don't have to buy the book. You can just go to the website. But the book is kind of the greatest hits from the registry.
I was going to say, don't tell your publisher that you've just offered the option of our viewers not to buy your book. But anyway, okay, so we've got wrongfulconvictions.ca. You've got the commission, the idea of a commission, an independent commission before Parliament right now that you hope gets through. What else? One more idea that you'd like to see happen to improve this situation.
Compensation. So Justice Laforme and Westmoreland Traore recommended no-fault quick compensation so people can get on their feet. The wrongfully convicted get less support than those who get parole, and that's not included in the bill. The other thing that's not included in the bill, and I think politics is one of the reasons, is they recommended, what about sentencing? What about you're not wrongfully convicted, but your sentence is based on the wrong facts, right? In New Zealand, they have a new commission with 2 Maori and 1 Pacific Islander commission. Their first case they referred to was back to the courts saying, you thought this kid was 17 when you sentenced him. Actually, we think he was 15, and we think that makes a difference.
I have one last question for you, which is, it is a big justice system out there. There are myriad issues to care about. Do you know why you care about this one in particular so much?
Well, I think that I couldn't think of a more alienating being alone if I was wrongfully accused of a crime. And early in my career, I appeared before Justice Fred Kaufman, and it was my first appearance, and he was very kind to me. And when I read his autobiography, I realized that he was interned as an enemy alien when he fled Vienna 1 step in front of Hitler. And to me, that was a real lesson. And so people like Fred Kaufman, people like the late Mark Rosenberg, who cared about these, are people that I look up to. And I just think, the wrongfully convicted need some allies. And like Jerry Garcia said, it's probably, it's pathetic that it has to be me.
Lucky for them, it is you. Wrongfully convicted, guilty pleas, imagined crimes, and what Canada must do to safeguard justice. And we're glad it has brought Kent Roach to our studio tonight on TVO. Kent, thanks so much.
Thank you very much, Steve.
With thousands of in-depth interviews and discussions, The Agenda's YouTube channel delivers context for virtually any topic you're interested in. Check out our latest videos and playlists at youtube.com/theagenda. And make sure to hit the subscribe button to get notified about all our new conversations. It's all available at youtube.com/theagenda.
In the aftermath of the Second World War and the atrocities of that brutal assault on humanity, the nations of the world reached a new agreement, the Universal Declaration of Human Rights. It set out in its first article that, quote, all human beings are born free and equal in dignity and rights. That document turns 75 years old in 2023. Has that declaration lived up to expectations? And is the movement that sought to ensure those human rights still relevant? Let's ask. In Silver Spring, Maryland, Seth Kaplan, professorial lecturer in the Paul H. Nitze School of Advanced International Studies at Johns Hopkins University. In New Haven, Connecticut, Samuel Moyne, professor of law and history at Yale University and the author of Not Enough: Human Rights in an Unequal World. And here in our studio, Farida Deef, Canada Director for Human Rights Watch, and Sandra Wisner, an international human rights lawyer and director of the International Human Rights Program at the U of T's Faculty of Law. And we are delighted to have you two here in our studio. Samuel and Seth, great to have you on the program, too, in Points Beyond. I just want to start with a very open-ended question. Seth Kaplan, get us started. Has the modern human rights movement proved to be, ultimately, ineffective? What's your view?
I would say yes. Human rights had an enormous impact in the years after World War II. Look at decolonization. Look at the delegitimacy of the Soviet Union. It eventually fell. Look at South Africa. But in recent years, the human rights movement has become too Western, too top-down, too ambitious, tried to do too much, and lost its focus, and is increasingly irrelevant and ineffective in most parts of the world.
Farida, what say you?
Well, I mean, the goal of the human rights movement is to expose human rights abuses around the world, to amplify the voices of victims of those abuses, and to make it more costly for governments to behave in a repressive manner. And so that's what we're doing, essentially every day, increasing the cost, the political cost of repression.
Sandra.
You know, I think that we all sort of have a different definition of what the human rights movement is, when it began, and I think it's probably more important that we reframe the question and to say, what can a system of law realistically hope to achieve? And we know that no legal system is better than the society within which it serves, and you know, the more cohesive that society, the stronger the legal framework. But law alone is not going to, you know, bring about that change, although it is an indispensable tool for change. But it really does need to come alongside, you know, societal attitude and changes.
We'll pursue that more in a bit. Samuel, how about you on that original question of whether the international human rights movement has ultimately proved to be ineffective?
I think it succeeded spectacularly in one respect. It has stigmatized bad actors, and it allows a vast number of people around the world to look down on those who are transgressing really fundamental norms. The trouble is, it hasn't really succeeded in changing behavior very much. But then there's another problem, which is the goals it set for itself have been too limited. The human rights movement hasn't been a peace movement or a socialist movement, and yet we know our world is riven by war and inequality, and we need to think about those much broader problems alongside the narrower concerns that human rights movements have taken up.
Farida, if it has had triumphs, point to one. What would you say would be a great example of a successful instance of human rights advances?
Well, there's been a number, but just to point to, you know, a number of war criminals have been brought to justice. They've evaded justice for years. The International Criminal Court is actively pursuing them. And so in that sense, it is creating a deterrent effect. Are autocrats still being repressive? Absolutely. But are the stakes higher now? Are they, you know, essentially looking, you know, kind of concerned about where they travel? May they be, you know, they might be pursued through prosecution. Are they worried that they might end up in the International Criminal Court? Yes. So I think that there have been instances where we see over the course of the past few years a number of advancements in terms of justice for victims of human rights abuses.
Sandra, what's on the top of your list?
I mean, I think one thing that I think is important is that this Universal Declaration of Human Rights that you mentioned, I think it's had a lot of successes in terms of inspiring other domestic states to incorporate those rights into their legislation. Here in Canada, our Bill of Rights, you can see that it was a clear attempt on the Diefenbaker government's part to incorporate those rights into our Bill of Rights. And then you see with our charter that succeeded it, that it was a clear attempt by the government to incorporate the rights of the International Covenant on Civil and Political Rights that we had signed on to in 1976. And so I think that that's inspired a lot of different movements around the world that's been very useful.
Seth, your concerns notwithstanding, is there anything at the top of your list that you would point to and say, that's an unambiguous victory?
I mean, the unambiguous victories were those that happened in the past. I mentioned the Soviet Union. The fall of the Soviet Union, human rights played a major role. I mentioned South Africa. I mentioned decolonization, which is an outgrowth of these rights. But I would say today, look at Syria. Look at if I'm a Uyghur in China, if I'm a Syrian who has been bombed or jailed or brutally killed by my regime, or if I'm in Africa or some other country and simply the police, not a systematic effort, but the police on a daily basis violate my rights. What is human rights doing for those people? And those people are in the billions. We're talking a quarter, a third, a half of humanity knows nothing about these rights and are not being helped by these rights.
Samuel, those are pretty profound questions. How would you answer them?
I think human rights movements have done well when they've done well in targeting relatively weaker actors like African despots and warlords. But George W. Bush and Vladimir Putin, who helm great powers and have done far more damage to the world, have been let off the hook. I agree completely that the greatest successes are in relatively more democratic countries that decide to have human rights as part of their domestic law. And then human rights can become about citizens' movements challenging their states from within, and their successes can be extraordinary.
Let's pick up on some of those names. Farida, do you imagine for a moment that Vladimir Putin worries about what the international human rights movement thinks about what he's doing?
I think he does. I mean, I think when you see the targeted sanctions that have been put in place, where Canada, in addition to other countries, have imposed widespread asset freezes on a number of high-level Russian officials. They can't really travel freely anymore. Their assets are frozen. There's certainly, it's not unfathomable to imagine a situation where President Putin would find himself in the International Criminal Court. And so we've seen, with respect to Ukraine, there has been all of the tools in the toolbox have been used, right? We talk about targeted sanctions, an international criminal court referral, resettlement for Ukrainian refugees. So it's really, despite the abuses on the ground, there is more of a spotlight on the human rights situation in Ukraine and the perpetrators than ever before. And so that, I think, is a win. And, Seth mentioned Syria, for example. Yes, are we seeing that, 11 years into the war, abuses remain? Absolutely. But at the same time, you've seen a number of wins, even over the past year, where a court in Germany, for the very first time, actually, in a landmark victory, tried a Syrian official for widespread torture. This was using the international human rights movement's, a mechanism called universal jurisdiction, which means that any country, even if the abuses didn't take place in that country, even if the victims are not from that country, can pursue justice for the most serious international crimes. And that's what German courts are doing, the Swedish courts are doing, in order to pursue justice where it's been closed off.
Well, let me follow up with Seth on that. Do you think Bashar al-Assad or Xi Jinping worry about the international human rights movement when they are doing the horrors that they are doing?
I mean, what they will do, because today there's so many rights that are talked about, they will come up and say that we're helping our societies develop economically. This is especially the Chinese case. We're offering social services to our people. And so they can look at the long list of rights that are promoted today, and they can say, we're doing a lot of these. And actually you democratic countries in the West, You have people who have homeless, you have people who are poor. So when we make rights about everything, these authoritarian regimes can turn around and say they're doing a better job than we are. We're forgetting the history of these successes. The history of these successes were achieved because they focused on a small number of rights, religious freedom, conscious freedom, to think as you want, to say what you want, due process, rule of law. When we forget the basic rights that won these battles and we focus on everything, the authoritarian regimes not only are not scared, but they turn around and use rights against us.
Sandra, what do you think of that characterization?
Yeah, I mean, I think what he's saying there is just that perhaps you're diluting rights by expanding them, or you're picking and choosing. But I think if you look at what happens in the international system, you know, it tends to be that rights are reflected from the international society and reflect what is of concern to the international society. And so, you know, that this is a consensual system. I think we have to remember that this is a system of law. It's sort of a rule of law framework whereby states can choose how to protect, you know, individuals and their human rights, and individuals have access to institutions and mechanisms whereby they can protect their rights if their national system fails to. So, you know, I think we have to work within the confines of that consensual system, and I think that's important.
Well, okay. Seth, let me get a little more explicit about this then. No, forgive me. I'm going to go to Samuel on this. Samuel, we understand that the right not to be tortured, everybody can agree on that. The right to a fair trial, everybody can agree on that. We are now hearing calls for things like internet access or free university, labeled as basic imperatives of human rights. Does expanding the definition of what constitutes a human right, in your view, that way, dilute the term?
I don't think so. Human rights are just a way of expressing what we take to be our ethical priorities right now and to push politically. And it's not true that expanding the list of what we care about makes it harder to get things. It would be absurd if I sat in Canada and said the government has allowed me to speak freely, so it doesn't need to provide me health care. And that's going to be true on the global level as well. It's hard to get any rights. You said that everyone agrees about the right to be free from torture and unfair trials, but that's false. And actually, we have to work not just for all kinds of human rights, including new ones if we need them, but a lot of other ends beyond what the human rights movement has proposed so far.
Seth, your take on this issue of the expansion of the notion of what constitutes a basic human right?
I think those goals are admirable, but we need to differentiate between goals that are a product of policy or politics that we believe are important and human rights. If everything is a human right, if I have a list of 100 human rights, China can mark off 95 of them, and it can lock up 1 million people and say they're doing great because we're not doing good on several of these social issues. I think the social issues are very important, but we need to differentiate between what is most important in terms of a few rights that we can join together, which everyone across cultures, across political divides can agree are important. So there's a global consensus on what we really should focus on, and that is the only way we're ever going to hold China, Russia, Syria, etc., accountable for how they treat their people.
Farida, can I get you to weigh in on that?
Sure. I mean, the global consensus is the 30 articles in the Universal Declaration of Human Rights, right? And those are everything from the right to life, the right to a fair trial, to the right to food, the right to basic housing, the right to employment, the right to education. There's no way for us to determine that certain rights are more important than others.
Really?
Because
There's no hierarchy on that?
Well, there's no hierarchy, just because it depends on where you live, who you are. Right? And so these rights are fundamental basic rights that should be taken as a whole. And when you think about sort of newer rights, you mentioned the internet, for example. You've seen a number of countries lately, India, Myanmar, Bangladesh, during times of tension, crisis, election, armed conflict, decide to arbitrarily shut down the internet.
No, I get it, but I wouldn't assume that the right to internet access would be taken with the same level of seriousness as the right to not be tortured.
No, it's not the right to internet access. It's the right to information. It's the right, because that information is also critical for health and for safety, right? Those rights are interconnected. So we saw what happened during internet shutdowns during a pandemic. People couldn't access in India vital information that was important for them to protect their families and themselves. And that was essentially a right to life issue, a right to health issue.
Seth, you want to come back on that?
Yes, actually, if you study the Universal Declaration, there is a hierarchy built into it. There's a small number of rights that are very tightly written so that there's no scope for changing or interpretation across boundaries. And then there's a second tier of rights, the ones that she's referring to, that are universal, but there's much more scope for interpretation by country. So, for example, the ones that there's no scope, they're very tightly written, and they're meant to be a higher priority, are protections against genocide, slavery, torture, inhumane or degrading treatment or punishment, deportation or forcible transfer of population, discrimination, and protection for freedom of conscience and religion. They built a hierarchy into the most important human rights document. And if I also refer back to something that came up before, the Universal Declaration is not a legal document. Human rights are not going to be promoted with legal mechanisms. They're only going to be promoted on the moral authority of the case that is being made across cultures, across political dispositions, across the North, South, East, West. Only when we focus on things that are so essential that no one can disagree with them can we build a global consensus that can actually make a real difference.
I should get Sandra to weigh in on that as well. Do you think that this, I don't know, are we diluting the notion of what constitutes a human right when we say internet access and freedom from torture are essentially equally important?
I mean, I think we have built into the system of international human rights a differentiation. That's why we have sort of customary international law, which is whereby, you know, we have states who are acting in a certain way, who are giving opinio juris, and they're indicating to us that these rights are extremely important. And I also think that, you know, if we listen to the international community, they are telling us what rights are important to them. And I think that sort of lends itself into treaties, into the treaty process. So, for instance, when the UN Human Rights Council brought forth that resolution recognizing the right to a healthy and safe, clean environment only 2 years ago now, that was after you had sort of 80% of UN member states who had actually signed on to that and prescribed to that right themselves domestically. And so that was a natural progression. And you can, I mean, it's obvious that we care about that right now. Perhaps, you know, it is incremental change, and that's another topic. But you see that, and that's now why we have last year the UN General Assembly also passing a resolution acknowledging the right to a healthy environment.
Okay, let me go off on a different tack here. Samuel, I'll bring you in on this. Would you call the international human rights movement a movement that promotes world peace?
It isn't. It actually arose and became prominent on the ruins of peace movements that were once much more commonsensical to a lot of people, and for very good reason. Actually, in our time, especially in the 1990s, human rights movements occasionally argued for war, in particular for humanitarian intervention to save civilians. And what we can reflect is that our ancestors understood the importance of constraining great powers, those like my country and Russia, and even middle powers like yours when they go to war, because human rights are most at stake when states cross their borders militarily. And I think it's tragic that human rights have monopolized the space of what we think will make the world a better place and lost other movements like peace movements and socialist movements that were actually much more popular in their time than human rights movements have been in ours.
Farida, let me give you a chance to weigh in on that, and in doing so, set it up by saying, you know, during the Obama administration, there were significant efforts undertaken by peaceable people who cared a lot about human rights to strike militarily in Syria and in Libya. So with that in mind, does the international human rights movement, is it a peace movement in your view?
It's not a peace movement. Essentially, I mean, most human rights organizations don't take a position one way or the other in terms of armed conflict, in terms of issues of state sovereignty, about whether or not a country should go to war or not. What we're concerned about is how, the way in which wars are waged, the types of abuses that are happening. Are, countries using landmines, which are prohibited weapons? Are they using chemical weapons? Are they targeting civilian areas, unlawfully and arbitrarily? So the way in which countries wage war is what we're concerned about.
Gotcha. Okay, Seth, over to you now. You've written that human rights movements are overwhelmingly led by Western countries that regularly denounce countries in the global South for their perceived abuses. Do you think that's problematic?
Yes, I would say Western countries, Western money, Western-based organizations. I think it's unfortunate. It means that human rights has become very monocultural. It reflects the views of a relatively small number of people. The human rights field is not accountable, and it's not reflective of many cultures and views, and that's why it has lost its universalness. And if you go back to the things I said before, if you stick to the basics, you can build a universal consensus across cultures and different political views. If you reflect the views of people from one culture or one set of people within those cultures, you are very likely to produce rights and produce arguments that have very little bearing on people's lives. And I would just say in general, there's a condescending attitude too often in the human rights field. I mean, I can speak from talking with Africans and people in the Middle East. They may agree with many of the ideas. They just don't like the way they're talked to. They don't like the lack of appreciation for their religion, for their communities, for their countries. And it causes problems that should not be part of the human rights field.
Samuel, your view on this? Too narrow, too Western a base? What do you think?
I think it's certainly true that the lion's share of funding for human rights activism not only comes from the West, but really one person in the West, George Soros. Beyond that, I think it would be a mistake to claim that there's been a decline in kind of global participation. Remember, there were only 50-odd states that existed at the time of the Universal Declaration. Now there are close to 200. And in fairness, the human rights movement, though funded out of the West, has become much more participatory in including lots of global Southern activists. What's essential, though, is that as soon as you begin consulting global actors, you have to change your priorities beyond Western ones, focus narrowly on free speech and other civil liberties. And that's because global actors are concerned about war and peace in ways that human rights movements are not. And they're concerned about fair distribution in the unequal world that almost requires most funding to come out of the West for human rights and any other reformist cause.
I guess, Frida, I should ask you whether you see anything particularly wrong or unjust about the fact that much of the momentum in your movement comes from the Western world. If the West is, prepared to put the money and resources into this fight, is there anything particularly wrong with that?
I mean, I don't think that much of the momentum comes from the West. In fact, it could be that big international human rights organizations, certainly like my own, have a very large megaphone. But that doesn't mean that the women's rights movement, the labor rights movements aren't active, actually more active in non-Western countries to some degree than actually in the West. So when you think about all the rollbacks that are happening on reproductive rights in the United States, at the very same time that was happening, you saw the women's rights movement in South America, in Mexico, and Colombia actually push forward and increase reproductive rights and health rights. And so there's ways in which even when you think about domestic workers who are among the most exploited workers in the world, it was the result of labor rights movements, of migrant rights groups in Asia that pushed for better protections and an international labor organization treaty on this. And so when you think about it, there are very, very active movements across the world. It just might be that we're not hearing from them. They don't have a large megaphone, but they're actively working in this space. And they've actually resulted, even when you think about the former Liberian president, Charles Taylor. He was in exile in Nigeria for years, evading justice, evading the reach of the International Criminal Court. And it was African human rights activists who actually pushed the Nigerian government to actually, send him to The Hague for trial. And so really, I think we disparage these groups and the movement if we look at only a few kind of organizations that are active in this space, when in fact, you have a very active movement across issues, from disability rights to migrant rights to LGBTQ rights, that are active across the world.
In which case, Sandra, how optimistic or not are you about the future of the international human rights movement?
I mean, I think there's a lot of changes sort of going off of what Frida said. I think there's, I was trained in movement lawyering, and that's something that is sort of new to the NGO field, and it really is meant to sort of listen to grassroots movements, and just sort of be a part of them and have those legal victories be guided by that activism. So I think there's lots of hope there. I think personally for Canada, there's lots of exciting things happening. I think the UN Declaration on the Rights of Indigenous People that the UN recognized in 2007, Canada didn't, but Canada has since decided that and explained to the UN that it will incorporate and conform its statute book to the declaration. And so I think that's something to look forward to, and to see if the political will be there to make that happen.
Samuel, do you think that the public is too impatient in its hope for evidence of more victories for the international human rights movement?
I actually think the human rights public is shifting away because it's impatient with how narrowly human rights organizations have set out to change the world. Young people today now see that, as Farida said earlier, human rights movements only signed up to humanize war rather than keep it from happening. And they certainly have never been socialist movements, whereas young people are adopting more ambitious causes to sit alongside human rights movements in order to restore them to their proper place, which is narrow and small.
Seth, what's your view on this notion that young people today aren't going into the international human rights movement in a way they may have in the past because they just don't necessarily see it as the best vehicle for progress?
If we look globally, and going back to your earlier question, I mean, I'm optimistic because rights as an idea is out there in the world, that young people in different parts of the world are going to be engaged with human rights and are going to work to promote them within their countries. In terms of the West and what we see in front of us, I think Sam is right that human rights is not so attractive. I think it's lost its credibility. It's lost its importance. I think I would disagree with the cause. And again, I think the human rights movement, or the industry that's human rights, if it wants to be relevant, it has to be relevant in challenging authoritarian regimes that treat their people awfully. And we have to be asking ourselves, what is needed to challenge China? What is needed to challenge Syria and other countries like that?
Farida, that sounds like a real shot across the bow there. You've lost your credibility and importance. What say you?
I think human rights in general are more important now than ever before as a lens to look at all kinds of existential crises that we have in the world today. And it's not the responsibility of the human rights movement to end all human rights abuses in the world. Certainly, first and foremost, it's up to governments. Governments are the ones tasked with guaranteeing the human rights of their people.
But you've got to light the fuse.
But we have to light the fuse. We're ensuring that we're stiffening their spines, right? That's our role, is to put pressure on them, expose abuses, expose inaction, and push them, and to raise the costs of inaction and raise the cost of repression. That's the role of the human rights movement, and I see it more important today than ever before. But also, I see wins here. I see repressive autocrats more isolated than ever before. Crown Prince Mohammed bin Salman of Saudi Arabia has to think twice about where he travels in the world. President Putin will do the same, just because of the reach of justice and the pressure that's being put on actors, on countries and their allies to pursue justice in these cases.
Samuel, do you see enough spine stiffening happening courtesy of the human rights movement?
I think there's a lot. And I think, as I see it, human rights movements have an essential role to play. But they also need to recognize that there's not just their causes, but social and global justice generally that's at stake. And they do have a responsibility to be clear about what goals they're advancing and where others are needed. And human rights movements may need to have stiff spines, but step aside for others, movements with even stiffer spines and more ambitious goals.
Sandra, what do you think of that advice?
I mean, I just think it's interesting because a lot is being put on the sort of civil society movement, and I find that really interesting. I think that there is responsibilities there when you take on that type of role. And there's lots of challenges and lots to be done, especially with focusing more on economic social rights, which I agree with. But this is up to all of us. This isn't just up to whatever this human rights movement is, but it's up to all actors. This is an international society, and we're all a part of it, that fabric. And I just think that we need to zoom out a little bit and try to work with everyone on these problems.
Is your megaphone today as big as it once was?
Sure.
You think yes?
I don't know. I think that, I don't know. I still think it's important.
Seth, why don't you take that on in our last minute here? Does this movement speak with as big a megaphone as it once did?
Depends on the audience. It's not very loud in the places where it's most needed, but it's certainly loud in our countries. And I would just say it's not reaching the people it needs to reach, and it needs to reconsider how it can amplify its voice and amplify its message to make a greater difference in the world today.
Well, I want to thank the four of you for coming on to TVO tonight and amplifying the message and having the conversation here on the agenda. So let me thank, in our studios out of town, Samuel Moyn, the professor of law and history at Yale University, Seth Kaplan, professorial lecturer at Johns Hopkins University, and here in our studio in Toronto, Farida Deef, Canada Director for Human Rights Watch, and Sandra Wisner, International Human Rights Program Director at the University of Toronto's Faculty of Law. Great to have the four of you on TVO tonight. Many thanks.
Thank you.
Thank you.
I'm Steve Paikin. Thanks for watching TVO, for joining us online at tvo.org, and we'll see you again tomorrow.
The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.